Day from the lands of the Turrbal and Jagera people, Brisbane. My name is Stephen Page from Page Provan in Brisbane, and I say greeting to all my UK colleagues. A change is about to happen on 10 June this year in Australian family law is about pets. There have long been disputes about pets and animals. I've been around so long that I recall back in the 1980s, a dispute in the Supreme Court of Queensland where a receiver was appointed as to the ownership of a horse. The couple had split up. The court then did not have jurisdiction about de facto couples, and so it had to be in the Supreme Court. And the costs of the receiver, no doubt, were far greater than the value of the horse, but that was back in the 1980s. Typically, arguments about pets occur when there has been domestic violence, and one party, commonly the perpetrator of domestic or family violence, holds on to the pet, using it as a kind of bargaining tool. So these changes have come in, or about to come in, and what they say first is that the court has a number of prescribed powers on a final basis that it can decide regarding a companion animal. A companion animal is not a support animal or an animal kept as part of a business, for example, a cockatoo in a circus, an agricultural animal, or an animal sadly kept for laboratory or experiments. Its powers granted to the court are prescribed. The court cannot, by these laws, do anything other than these three things: that the companion animal is owned by one of the parties or someone joined to the proceedings. Secondly, that it's owned by someone else with their consent, or it's sold. And one could imagine the second ground might be, for example, it's owned by one of the adult children, but there's no power to have a sharing of the animal. It's either or it's sold. And this contrasts with the position that the Prime Minister has actually taken in his own life. Anthony Albanese, during the recent election campaign, said that he shared his dog Toto with his ex, Carmel Tebbit, and Toto presumably moves between the two households. You can certainly reach an agreement about that informally. You can enter into a binding financial agreement to formalise the arrangements concerning that dog. But what you will not be able to do from 10 June is to obtain an order from the court to that effect. The court has to look at a shopping list of matters when it considers whether or not to make this order. And they are the circumstances in which the companion animal was acquired. Secondly, who has ownership or possession. Thirdly, the extent to which each party cared for and paid for the maintenance of the companion animal. Fourthly, any family violence to which one party has subjected or exposed the other party. Fifthly, any history of actual or threatened cruelty or abuse by a party towards the companion animal. Sixthly, any attachment by a party or a child of the marriage to the companion animal. So one would imagine in the ordinary course of events, depending on the facts of the case, of course, but where the child goes, typically so does the pet dog or pet cat. And then second last, the demonstrated ability of each party to care for and maintain the companion animal in the future without support or involvement from the other. And then finally, a matter of discretion, any other fact or circumstance which, in the opinion of the court, the justice of the case requires to be taken into account. So there you have it. From 10 June, there will be these specific powers granted to the court to make orders concerning animals, and they are certainly prescribed. Thank you for watching and listening today. I'm Stephen Page. Good luck with your changes in the UK.